A shocking move by Brian Walsh's defense dominates the day in Massachusetts. Did Brian Walsh change his mind at the 11th hour on testifying? And in Michigan, a standout college coach fired and now under fire criminally. And when will the Blake Lively and Justin Baldoni standoff end? The court of law has wrapped up for the day. Let's get right into Court of Opinion. Welcome to Court of Opinion. I'm Jenae. Thank you for joining us tonight for something a little different here on Court TV. This is a space to air out the opinions and viewpoints on the most talked about trials and cases. Our guests are going to shift a bit from just the analysis to giving us really how they personally feel about these cases. And we've got a brilliant panel of experts on deck for you today. And whether it's the court's final opinion or the court of public opinion, we have it all for you right now. Let's go to Massachusetts. That's been our biggest trial of the week. We now know that closing arguments are going to begin tomorrow morning in the case against Brian Walsh. Today was a big day. The defense had the opportunity to present their case, any evidence to this jury, but Brian Walsh changed his decision overnight. We're going to listen to it. Here's a look, in case you missed it, at the highlights today, this morning, when everyone got into that courtroom in the case of the death of Anna Walsh, who was dismembered by her husband, but he denies that he killed her.
At the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing?
Whether I'll testify or not in my trial.
Right. Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial. and that he's done so with the knowledge of its consequences. I accept his decision. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
Let's get right to our panel of co-counselors, our expert opinion that we're going to be getting. Joining us in studio tonight, we have family law attorney and law professor Randy Kessler with us. We also have criminal defense attorney Josh Schiffer here with us. So great to have you all. And also joining us remotely, Chief Public Defender for Oakland County, Michigan, Paulette Lofton. Good to see you, Paulette. Let's get right to it. Brian Walsh, what's your opinion on what happened last night? Randy, what happened? It sounded like he was set to testify and his attorneys were on board.
To be a fly on the wall, right? How great would it have been to be in there? I mean, Josh.
Oh, I did.
You ever broken anybody's arm? You ever twisted anybody's arm all the way around?
Seriously, his poor lawyer has got to have lost a few years at the end of the lifespan after a night like that.
If he was going to testify, at least then the lawyer's off the hook, right? It's all on you because they got you dead to rights. The only person that can save yourself is you, right?
It's not like they didn't promise the jury from the very beginning, you're going to hear about it. You're going to hear about it. But Brian, you tossed the dice early. Changing that now? Oh, man. Bad move.
After all that research by the judge, Paulette, have you had that happen to you? What's your opinion on whether or not the defense attorneys wanted him to testify or if he simply changed his mind and they probably are like, that's great?
As a defense attorney, I think the most risky thing you can do is put a defendant on the stand because as much as you prep them, it is a very unnatural situation for them. So obviously things are going to go unplanned. But yes, did this take a couple years off the defense attorney's life? Absolutely, because I am sure they prepped the heck out of him and were all ready for him to take the stand. And obviously overnight he had some change of heart. So
even the judge.
A very, very interesting day. Right. Yeah, the judge didn't seem pleased either. It seemed like she did quite a bit of research.
Oh, no, that telegraph was received loud and clear that she was frustrated about all the time she spent.
If I'm the lawyer, I'm almost like, you got to testify now because the judge is pretty mad at you.
Exactly. She's kind of an important person, and she literally spent time specific. This was a complicated multi-week trial.
And they brought the jury in. They brought the jury in this morning, and they could have rested yesterday.
Well, I think it's fair to say you never know what this guy's going to do. Don't come home and be alone in the house with him. You might end up in different parts and different places.
The problem is that once his defense started, it needed to go along a certain path. And part of that path was providing an explanation. Here's what happened when I found her. That's never coming out. Never. So he's now had to change the case to a burden case, and the state's done pretty good with their burden.
Paulette, go ahead.
If they didn't have an expert, really all they had was him. Maybe he could have turned on the charm. Maybe he could have explained some things away. But with no expert, and then he doesn't testify, and you present no witnesses, that is going to be an uphill battle.
I want to play something that may have been a reason that Brian Walsh decided he didn't want to take the stand and face having to be confronted with his own words. Because remember, he talked to investigators the very day that he reported his wife missing. They were there, the kids were running around, and he was like, whatever you need, I will help you. And they asked him this question. Let's take a listen back to that audio recording. All right, you know what? That's okay. A bit of a technical difficulty. I can read what it said.
I did.
Is she on any medication is what the officer asked, and Brian Walsh said, oh no, she's in great shape. Me, on the other hand, I had a cancer scare. I'm not in great shape, but she has no medical problem. She is nothing to the sort. How does that jive if he was going to have this sudden, unexpected death type argument?
That's the problem. Nothing jives, right? And you can say all day long you have a right not to testify, right not to incriminate yourself. You know those jurors are going to go back there and say, I'm calling BS on everything this guy said, right? It's just one more level of, oh, I dismembered her, but I didn't kill her. Oh, she was healthy, and I was unhealthy. I mean, what are they? He did say some things. He didn't testify, but they heard that. You know?
And that's gonna stay. That's going to stick.
It literally helps the state's case to have a buildup like that with no payoff in the end. He has teed it up through all of the cross-examinations done by his lawyers, and his lawyers are fighting for him. And his lawyers told him, hey, you said you were going to testify. We structured this case so they needed to hear from you. What are you doing stealing that from the jury now? Because it really was a theft.
It's almost like the jury's getting fed a comic line. Like, guess what? We're going to give it to you. We're going to give it to you. Surprise, we're going to pull the rug out from under you like a Bugs Bunny cartoon.
Yeah.
And the jury's like, okay, I know the law says we can't consider that he didn't testify, but I'm pissed off, right? I'm mad.
Paula, let me ask you this. When you have, and you know, you're a chief public defender, so I'm sure you're faced with this a lot. We know that the defense does not have to put on a case, and the jury is going to be told that. But what's your opinion on whether or not jurors really do penalize the defense? Because everything else in our society and in our lives, if you want someone to give you something like a not guilty, you've got to give them something.
Right. In voir dire, I always ask jurors, do you understand you can't hold it against the defendant if they decide not to testify? And of course, they all say, yes, I can do that. But it's human nature, right? You've been in a courtroom for weeks now where everyone is talking about you, and you decide to remain silent when there's so many questions about what you did to your wife. I think that is a hard pill to swallow for a jury, especially because they thought they were going to hear from him.
I want to throw in a couple of names that you all may or may not be familiar with, but I know our Court TV legal eagles are going to remember some of these names. We dug into the archives of people who did this unusual thing that Brian Walsh has done, where he's admitting to the tampering with the corpse, the manipulation of a body, but saying that he didn't have anything to do with the death. So these three men did something similar. We've got Dr. Ingolf Turk, who in the same courthouse said that, yes, he did bury his wife in a pond, put rocks in her pockets, but said that he didn't kill her. It was an accidental type strangling. It was manslaughter, not murder. Adam Montgomery did the same thing with the death of his daughter, little Hannah Montgomery. He said that, yes, he did terrible things to her body after she died, Harmony rather, but that he did not do the killing. And finally, Robert Durst. He at one point went on trial for killing his friend, Morris Black, and he was acquitted when he said it was actually self-defense, but I dismembered my friend, and put him in trash bags.
Incredible.
But those two people who got lesser charges or acquitted, they took the stand.
And that's because you've got to give, like Randy's talking about, the answer. If you're going to give them the setup, you got to give them something valid at the end explaining it. Disappearing, that's not a good defense.
Well, let's talk about why they actually did it, right? The conversation between the lawyer and the defendant was, all right, let me tell you the charges. This one, you're going down on. You dismembered, you hid the body. That one is a loser. This one, it's a pretty big loser, but not as much of this one. So you say, the one I'm absolutely going to lose, let's give that one up. Let's fight the one that's fightable. And the only one that was fightable was there's no eyewitness to the murder. That's the only reason. He could not have won the other one.
I think it builds credibility with a jury. I do this often. I just did this in a recent trial. Those charges that you are absolutely going to lose, and then standing in front of the jury and trying to say that your client is not guilty would insult their intelligence. I think a jury appreciates that you narrow down what they need to focus on and really attack the charges that you have issues with.
Yeah, you're making it harder than the jury. You're saying, look, we didn't give you the easy one. You know, we took the easy one right off the table. You got the hard one, and you're the jury. You got to give them the presumption of innocence.
And by concretizing it, by slimming it down, by getting much more discreet, that's how you get a more engaged jury, because it's not such a broad set of charges. It really is, what are we here for? Okay, we're just here about the death part. And at that point, if I'm defending this guy, I might not put up anything, certainly would not have done that opening, because the state doesn't have anything other than his post-death activities. Stronger than telling him you're going to hear from me and then not.
There's something that came up today, and they've been going back and forth on this the entire trial. It's whether or not the jury can actually get the evidence that he has pleaded guilty. It's kind of a secret from them, even though in openings they admitted to it. Is there a reason that the Commonwealth doesn't want that in on the record? They say it shouldn't be evidence in this trial.
Maybe for what Paulette was talking about. It gives him too much credibility. He stood up and he owned what he did that was wrong. And I think, since he's not going to testify now, it's up to his lawyer. And his lawyer's going to have to explain that.
It's that strategy of charge selection from prosecutors. They charge the cases the way that they want, that goes with their theory of the case. They don't include every potential possible charge, because that gets too messy. It's how you effectively manage a case, and whether that information comes in, it's a big interest to the Commonwealth.
Paulette, real quick before we have to go to break, your opinion on who else they could have called if they did not put Brian Walsh on the stand. Is there another person that you think they should have put in front of this jury?
Well, if they could have found a medical expert to back his claim that she just died of natural causes or an unexplained death, I think that would have been perfect. But the fact that they didn't probably means that there wasn't a doctor that was willing to say that.
Yeah, well, we are going to continue to talk about this case because even though the defense didn't put on a case, they did scrutinize some evidence while they were cross-examining witnesses and brought in their own theory of how they say Anna died. We'll get into the best of that next.
Tonight on Closing Arguments, will safety concerns trump public access in the Charlie Kirk assassination case? We'll bring you the latest developments from today's big hearing.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
A Microsoft executive gunned down. Now his ex and her new husband are charged with his murder.
A social media sensation, now a suspected killer.
She wrote a children's book about her husband's death. Now she's accused of killing him.
Today in Massachusetts, Brian Walshe shocked even the judge by showing up for court today, bringing in the jury for the morning, only for the defense to rest its case without presenting any evidence. But that doesn't mean the defense did nothing. During cross-examination of the prosecution's witnesses, our team went back through the trial to find several defense exhibits and some common themes that point to their theory of the case. So here's what our court of opinion team selected as the defense's best evidence. And it's the web searches. The defense on cross of this trooper asked if they were able to discover any searches from Brian Walshe from before December 27th about the disposing of a body. Now, this is a situation where these Google searches from the Commonwealth's case were damning. They had quotes of whether or not it would take a certain amount of time for a body to begin to smell. How do you beat a murder charge? Can you get charged with murder if there is no body? Those were bad, but the defense said that these were not done prior to the sudden death of Anna Walsh. Let's take a listen back to that moment.
It's fair to say that in the searches running from the date of December 25th of 2022 up and including the end of December 31st of 2022, you saw no evidence of searches in the Safari search history regarding any searches for things like tools or searches suggesting how to dispose of a body or anything like that, correct?
I did not see any of those December 25th to the 29th.
All right, let's bring back in our guest panel, see what they think. We have Randy Kessler, Josh Schiffer, and Paulette Lofton. And Josh, I'm going to start with you. What's your opinion on our selection? It was kind of slim pickings.
Yeah, I was going to say there wasn't a real deep bench to go down and figure out his strongest, because really it's the totality of the lack of information they need to rely on. There's two fears that every jury in a criminal case has: wrongful conviction and wrongful acquittal. And that's really gonna weigh on.
You oversimplified a little more, John.
But that's really it. And the jury goes back and goes, hey, am I gonna make a mistake convicting him, or am I gonna make a mistake letting him go? Right now, letting him go is a really tall order, because no one's explained how a perfectly healthy woman suddenly died, and then he admitted to chopping her up.
I think you guys did right. I think you picked the right defense, the best evidence, because you've got to set up the lawyer. If your client is not going to testify, then who's going to tell the jury what to do? It's the lawyer. So the lawyer has to have something they can use. They really had nothing until then. They had, well, the expert didn't really concede. Maybe it was an innocent death. But this, right? They brought in this expert witness to talk about Google searches. Ooh, he searched how to hide a body. Ladies and gentlemen of the jury, what would you do if you found your wife dead and you panicked and you tried to dispose of the body so that you didn't get accused of the murder? Then you have to figure out, what do you do? You Google search, what do I do? And that's what he did.
Paulette, should they be arguing something different here? I know they may, we'll see altogether for closing arguments. Should they be arguing that this was sudden passion, heat of passion, that he didn't mean to do it, of second-degree murder, versus what is, we expect, this sudden, unexpected death defense that's going to come out?
I think it would have been a very large stretch to argue it any other way. So I think the defense attorneys are doing exactly what they need to do. Google searches are horrible. They are really hard to overcome. So what the defense attorneys here are doing are trying to limit the time that those searches began. So it wasn't like we had weeks and weeks of him planning his wife's demise and then how to deal with the body. It's a very short time period. And if they want the jury to believe that she died of natural causes and he panicked and then he started doing these Google searches, I think that lines up with their defense.
That's all they got.
Yeah.
All they got. Everyone agrees. They don't have much. We did find something else. Let's take a look at something else that we looked at. And this was a defense exhibit. These are the text messages between Brian and Anna in the days leading up to her death. So December 27th, 28th, 29th. And this includes two from their sign-off, how they finished their conversation with, quote, "I love you," from Anna, and Brian Walsh responding, "I love you too," showing that things were well between them. I mean, that is what they leaned into. What's your opinion on that as defense evidence?
I'm a divorce lawyer by trade, right? You know, people say all sorts of things that they don't mean.
Oh.
You know, I'm out at the gym. You know, I'm out with the guys. I'm out golfing. You know, I love you should mean I love you. I wouldn't read a lot into that.
I don't know if there's an easier way to lie than text. There's no tone, there's no intonation. You just put it down there, and it is basically worthless. And come on. All of us know people like Randy's clients who will say lots of, "I love you, I love you, I love you," and then they see the files dropping. Not great.
Yeah, what are
a strong argument. I don't think that helps at all.
All right, so Paulette not saying this is our strong argument.
What does a husband do when he finishes having sex? Calls his wife. I mean, that's the old joke, right? People lie, lie, lie. I agree. A text is not the best evidence.
All right, we've got one more, and that one has to do with this defense of sudden unexpected death syndrome. And to Paulette's point earlier, it should have been something that we expected an expert to come in, because the defense even said it in their opening. They said someone is going to come in to explain to you sudden unexplained death syndrome. It made it seem like there was going to be someone from the defense to do that. Now, the woman here, this was an exhibit she was holding. It was identified by the defense but not published. But it is a posting on one of the buildings that Anna managed where there was a health department alert for Legionnaire's disease in that area. And this HR director was questioned about it. So you had this question of whether or not she really was sick, meaning the victim could have had some issue leading to this SUDS syndrome. Let's take a listen to that coming in through Dr. Atkinson, who was a state witness.
Sudden unexpected death can occur in individuals that otherwise appear to be healthy before the sudden death.
Yes.
And in fact, that's one of the references we've already talked about within the statute that we just talked about a minute ago. That sudden death occurring in someone that otherwise didn't have any manifestation of a physical illness or problem.
Correct.
I mean, it can happen, if you know, sir, it can happen as a result of travel or extended travel or things like that in a person.
Sure.
Paul, I want to start with you. They didn't bring in their own expert, but they used the state's expert. Does that carry the same weight?
I don't think it carries the same weight, but I think it carries some weight. Obviously, the doctor there didn't shut down all of their questions and agreed that this is a possible, maybe not plausible, but possible scenario. So definitely not the strongest, but they used what they had. And I think they did get some information out of that doctor that supports their theory.
Yeah, and there's something powerful about getting it on cross-examination. You know, when you put your own witness up that you've talked to, that you've prepped with, and you get them to say something, well, yeah, they're paying that person. That's who they prepped with. When you get the other side's witness to concede something, that's gold. So they got it from the state's witness. Ladies and gentlemen of the jury, we didn't have a witness come in and tell you that. Their witness, who was supposed to convince you that he's guilty, actually revealed that this could be a plausible explanation. It's valuable more because of who said it than what was said.
And it was a really skillful bit of cross-examination to do that artfully without pushing it. Because if you ask one question or push that witness one little bit too far, they're going to bite you back with some really bad testimony that's going to take away the gains that you just got, which is that, yeah, this could have happened. It's a real thing. People do suddenly die, and really the biggest symptom is death.
The reason for this cliches have a basis in truth, right? Drop dead. She just dropped dead. Well, where did that start? There are people that are healthy that just drop dead suddenly. You know?
And that gets back to the fear that jurors, man, what if she really did just die?
And there was a text message where she said that she wasn't feeling well a couple of days before. Closing arguments, though, are going to be big. That starts tomorrow morning, both sides, and we'll kind of hear where the defense is going to land this plane. Paulette, what do you think about where they should start? What's your opinion on where they should start in their closing?
So I think, with the topic we just discussed, it was a little seed of doubt that they plant. And that's sometimes all you can do with a jury. Have this earth-shattering moment as a defense attorney that the jury is like, wow, oh my gosh, I'm starting to believe the defense. But you just kernels, and then in your closing, you bring all those kernels together and argue reasonable doubt.
That's a really beautiful way of putting it, because the analogy of growing reasonable doubt, it is that seed that seems almost ridiculous at first. But the more you think about it, well, how many weird things have happened in your life? How many unexplainable things have happened in your life? If you're a good defense attorney, you can have jurors ask themselves that question. Have you ever seen something that otherwise wouldn't be believable by somebody else? That's then the fear of, oh, what if this guy really woke up and completely panicked when he found his wife dead, and now, because of the state, ends up here? He already pled to the stuff he did.
If they hear about it, we're going to learn about that tomorrow. We do have to leave it there. Thank you all for your comments. We've got to get to a break. When we come back, though, we're going to go beyond the gavel. We'll be breaking down our biggest true crime cases, and we have one in particular. This one, an accused school shooter, makes his first appearance in court since getting a new lawyer, and his change in appearance is turning heads. Stay with us. Let's go beyond the gavel. Those cases that haven't played out in a court of law yet with a trial, but the issues at stake have all eyes on the investigation while the process plays out. And that's the case for a 14-year-old in Georgia, Colt Gray, who's being tried as an adult for the shooting at Appalachia High School in Winder, Georgia. Here he is in court this week for a status hearing in front of Chief Judge Nicholas Prem, who is concerned that the case isn't moving quickly enough. Here are some details on what happened in that hearing this week. There's a new public defender who's assigned to the case for Colt Gray, and he's got a medical evaluation that was in progress when that attorney was assigned, and it is still in progress. It hasn't been completed. It's expected to be completed in February, and the next calendar call for this case is scheduled for March 18th of next year. Meanwhile, the case also continues against his father, Colin Gray, in this unusual approach to school shootings by a prosecutor, the charging of a parent for not doing more to prevent the tragedy. So our panel is still with us. We've got Randy Kessler, Josh Schiffer, and Paulette Lofton. Paulette, I want to start with you. You're the chief public defender out there in Oakland County in Michigan, and you actually represented someone in a similar position of this parent, Jennifer Crumbley, the mother of the Oakland High School shooter, Ethan Crumbley. What's your opinion on how the criminal justice system is handling this case?
So for a judge to say the case is not moving quick enough is ridiculous. These type of cases are something that happen to a defense attorney once in a lifetime. Of evidence that you are given from a school shooting, every single student that is on campus that day, every single staff member, every single individual that had stepped foot on that campus that day is a witness, is a potential victim, and they have statements. The amount of video footage, phone surveillance, those things make it such a complex case for a judge to comment on the speed of how it is progressing is mind-numbing to me, especially because there's been a change of attorneys, which is kind of uncommon in such a complex case, because it's really hard to jump in as a defense attorney halfway through or months through, and then you have to start from scratch and look at everything for the first time as a new attorney. So I am not shocked that this is moving slow. That's what needs to happen, especially because there's a parent charged. So you have to play everything out. Do you want the dad's trial to go first so that public opinion is different of your client? that's something definitely that we had to consider. So there are all these moving parts that I don't think the judge is considering when she made that comment.
No, thank you for those opinions, Paulette. And I do want to correct myself. I misspoke. You actually represented, we saw you there in that video with Ethan Crumbly, who you were representing, and they had to get outside counsel from the public defender's office to represent the parents. Guys, weigh in on this one for me. This is a 14-year-old in Georgia. That's where you all practice, and he's tried as an adult.
Yeah, it's a unique and hard case, and getting a public defender for death penalty is hard in all 50 or any state. So the judge, I think, is posturing a bit with the, I want this to go faster. I think that's playing to his voters and the populace and trying to look good, because there was no way this was going to get to trial quickly.
Yeah. And Paulette's right. There's so many moving parts. You know, and it even benefits the state to some degree, because the older he is, the less sympathetic he is. You're trying a guy, a 14-year-old, well, if he looks 18, he looks, you know, a little bit more like somebody who could have done something. So, you know, and I like these moving parts. The father, what's the father going to do? I mean, God, can you imagine? This is Solomonic. It's like in the, you know, it's biblical. What do I do? Do I fall on the sword for my son? Do I say that he did it because I did it and I made him do it? Or do I point the finger at him? There's so many moving parts to sort out. And you want a clean trial, most importantly. If he's going to be convicted, you don't want an appeal, you don't want it overturned. There will be an appeal, you don't want it overturned.
And that's a big part of it too. You mentioned the father. I mean, it's on the minds of so many people, especially we're in this week, unfortunately, the tragedy out in Kentucky with the university campus there having that shooting and the suspect being someone who's a father of a student. So we're thinking about prevention and accountability and solutions, and there's this approach now to holding others accountable. Let's actually take a listen to the body camera footage that was really used in bringing the charges against the father, Colt Gray.
We do a lot of shooting, we do a lot of deer hunting. He shot his first deer this year. You know, so like I'm pretty much in shock, to be honest with you.
That was Colt Gray speaking before the shooting that was allegedly done by his son, where his son had been alerted. Police were alerted to him because he had made these suspicious comments online that seem to point to violence, and he's mentioning they have guns. He keeps them away from his son. That turned out to not be the case.
Well, we're trying to figure out what to do as a society. How do we stop this? You know, punishing the person who did it isn't stopping it. It's still happening. Maybe punishing the person who gave him the gun. You know, we're going so far as to maybe punishing AI and chatbots. I mean, we got to figure out how to stop these shootings.
Academically, that's really the fascinating part. And this case is completely different if you remove dad from the equation. Remove dad from the equation, it's a single-person crime. It's thoroughly documented. It would be a straightforward prosecution outside the age issue. The dad? What are they using the dad's case as leverage against a kid in a death penalty? There's a whole universe out there about that. I followed the Crumbly case really closely. Shannon Smith's a good friend of mine. That case academically had the entire criminal defense bar of the nation gripped on it because of the expansion of criminal liability to people that didn't take an action.
Was it going too far?
Yeah, exactly.
Do you think that?
Well, I think that they've got a great case for what it is if they're the state in Georgia, but the father has one of the finest lawyers to walk Georgia soil, Jimmy Berry, and this is going to be appealed, appealed, and appealed. Guns are part of life in Georgia. If you're going to get locked up for them being used by someone else, folks care about that.
Paulette, that accountability seems to be expanding. Even this year, just about a month ago, we saw in court a principal who is being held liable for a 6-year-old shooting his teacher, and she's also facing charges. That's Ebony Parker there in Virginia. Abigail Werner was the victim who was shot. And this is unreal for us to see someone who's a school administrator potentially going to jail because a 6-year-old brought a gun to school and she didn't do more.
Right. I think there's been more and more research on school shooters, and it's been proven that before someone gets to the point that they are going to shoot up a school, there are signs and symptoms. There are cries for help. And unfortunately, as a society, we have not been doing a great job at recognizing those. So I think the line of thinking is a parent, obviously living with this person, should have seen the signs and symptoms and maybe should have stepped in and made sure that the gun was not available to someone going through a struggle.
I mean, Josh made some good points. He always makes great points, but we're in Georgia. I mean, those people on the jury, they got guns.
Yeah.
And their kids might use their gun. And they're thinking, you know, but for the grace of God, go I. You know, it may be their child one day that takes a gun and does something. So it's a tougher case in Georgia.
And if a juror thinks that this is an end around to the Second Amendment, that creates a whole conversation back in that jury room neither side really wants people talking about. That will ruin a jury's effectiveness and cohesion.
What can the criminal justice system do better when it comes to accountability and comes to these school shootings? Because the more the people see them, the more they want things to change.
Where do we start?
Yeah, the fact of the matter is guns are in America. They're going to be all over the place. And it's not the existence of guns. It's the availability of guns when someone is having a violent moment. And here's the problem. Everyone has a violent moment. I have, Randy has, you have. Everyone's lost control.
Josh is having one right now.
Randy and I are like, wait a minute.
I sucked last Tuesday. No, but seriously, it's not the existence of a gun. Is a gun available when there's a crisis moment? Because that's when otherwise wonderful, beautiful people make indefensible decisions that land them in prison for the rest of their life.
Oh, the gloves are off. Panel, you all gave great opinions. We appreciate it. We've got to get to our break and leave it there. We'll, of course, give you updates on the Colt Gray case when we have them. Coming up, our hot takes and cold facts. Our panel is going to give us their opinions on some of the biggest cases and headlines right now, including a fired football coach now perhaps facing criminal charges, a minor publicly shamed, and the pending trial for feuding movie stars. Stay with us.
Tonight on Closing Arguments, will safety concerns trump public access in the Charlie Kirk assassination case? We'll bring you the latest developments from today's big hearing.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
The Microsoft executive gunned down.
Now his ex and her new husband are charged with his murder.
A social media sensation, now a suspected killer.
She wrote a children's book about her husband's death. Now she's accused of killing him.
Welcome back. Our Court of Opinion experts, they have strong takes on all of the trials we bring you here on Court TV. And now we want to get their hot takes on the big legal headlines developing today. And because we want to get to all of them and hear from them and all of these cases, just like in a court of law, our seasoned panel will make their arguments and we'll give them 25 seconds on the clock to state their case. Before we get to their hot takes, here are the cold hard facts on our first headline. This one out of Michigan. Former coach, head coach of the university there, Sharon Moore, he was fired for an inappropriate relationship with a staff member and now is reportedly in jail as police investigate an alleged assault. Now, authorities have not released formal charges yet, but they did respond to questions about Moore, saying that there was an arraignment on Friday. This incident, they say, quote, does not appear to be random in nature. The school now looking for its third coach in 4 years. Let's bring back in our guest panel, Randy Kessler, Josh Schiffer, and Paulette Lofton. Josh, let me start with you. What's your take on the coach?
Coach is done coaching. He is no Bill Belichick. He needs about 20, 30 more years of experience, and he needs to make far better personal decisions. Let's just look at how who you date can ruin your career. We got some of that here in Georgia.
Hold on just a second. We're going to let the clock run out, and then we're going to put 25 seconds. You actually had time left over, Josh. Are you surprised?
I am. I'm gonna give that to Randy.
All right, Randy Kessler, your take, 25 seconds on the clock.
So he's had 2 prior incidents. This is his 3rd one. Strike 3, you're out. I know I'm in the wrong sport. But, you know, what he did is bad, and I just want to quote Josh. Josh talk about, you know, who you date. Well, what's really important here, he didn't beat Ohio State. I mean, that's the biggest crime in Michigan, and it's bad what he did. It's bad what he is accused of doing. But he wasn't going to coach there anyway, given the way this season ended and last season ended. And, you know, he shouldn't have done what he did. Let it be a lesson. Glad they took action. Glad they're getting rid of him. If he's guilty, he should be gone. And even if he's not guilty, the way he coached, he should be gone.
All right, time's up. Paulette, let me just get your thoughts on this coach who was just fired for something inappropriate. Now that's elevating to something that's perhaps criminal.
It is really hard to feel bad for someone who is being paid $5.5 million, and that appeared not to be enough. He needed to do something extracurricular. So very hard to feel sorry for him if these allegations are true. I agree. I think he should be let go. I think it sends a very bad message to the young men that he's coaching. And it puts the team in such a horrible position after all the troubles that they've had over the last couple of years. Bad decisions.
And that arraignment again Friday morning. So tomorrow in opening statements, you can watch us get into the details of that on Court TV with Julie Grant. Let's get to headline number 2. We have this minors perp walk from the sheriff in Volusia County, Florida. That has a lot of people talking. This sheriff office publicly identifies and perp walks minors who are arrested for felony-level school threats. This is a policy that they launched in September of 2024, and it has sparked a lot of controversy because Florida law does allow minors' names and photos to be released, but some kids have been publicly shamed only to have these charges dropped, raising a lot of questions. And we're showing some video of some of the things that they've done. That's defacing property, graffiti, different things like that. It's a question about fairness and the long-term harm. Randy, family law attorney, you deal with custody and issues like that. 25 seconds. What's your take on this one?
With young kids, you want to give them a chance to get back on track, right? And if they're innocent, you're already ruining it for them. And even if they're not innocent, you want to give them a chance to get back on track. This is not to punish them. It's to get them back into society. Perp walk, what are they watching? Game of Thrones? They're going to embarrass them because it's fun and they can go back and tell their family, hey, we paraded this kid and look, you should have seen the look on his face. What are we doing here?
Paulette Lofton, what's your take on this sheriff's approach to perhaps trying to curb problems at school?
This is not scared straight. This is an embarrassment. And obviously with social media, anyone can find the names of these juveniles now. And is that going to follow them for the rest of their life? That's not teaching them a lesson. That is just an embarrassment. And I definitely think it should be stopped.
Josh Schiffer, what do you think the sheriff's goal is here? What's your take on whether or not this is to try and curb issues? And I can already see your face.
Yeah,
Let's get your take.
Sheriff's
25
goal,
seconds.
Sheriff's goal is, I like getting elected. Why don't y'all give me some money and keep putting me up here so I can abuse children openly in public? Because that's what this is. It's child abuse. These children are being accused unilaterally by the state before they've gotten any due process, and they're being paraded like caught fish in front of a herd of cats. You've got to be kidding me. Someone needs to go down to this sheriff, give him a dose of his own medicine.
All
This
right,
is
Josh.
disgusting.
Okay, Josh's opinion on that child abuse. Of course, no criminal charges have been filed in a case. Let's go to our headline number 3. The trial between Blake Lively and Justin Baldoni. It's been delayed again. It's been pushed back to May 18th, 2026. This case keeps going back and forth. It is a civil case. It has to do with really litigation between these two over whether or not this director took advantage of an actor in his film. They were supposed to be co-directors of this film, and even though that is said and done, they are still in court. Both sides are gearing up for major arguments next year over Baldoni's bid to dismiss Lively's harassment and retaliation claims, while settlement talks remain possible but undecided. Paulette, let me start with you on this one. I'm sure you've seen the headlines. Do you think we're ever going to see an end in sight in this case? 25 seconds.
Probably not, but I do love the judge's reasoning for this adjournment. She said that criminal trials take precedence. We don't get that very often, so I love the fact that that's the reason for the adjournment. But also, what court and what courtroom and court staff wants to hear that trial? We all remember what the Johnny Depp trial was like. That was months of just pure agony for court staff and the judge. So I think an adjournment is well warranted.
Josh, do you think it's going to be a Johnny Depp too if we get cameras inside that courtroom?
Well, I already know who won. The lawyers, because that's what this is this is lawyers sitting in golden rooms throwing paper balls at each other, wasting the time of the court when they could be handling serious criminal cases. That's just wrong. I love what the judge said, because the judge knows what's up. She's going to jam them up. This case never reaches trial.
Randy Kessler, 25 seconds before we have to go.
I think the judge got it right. I think Paulette got it right. And I think Josh got it right. This is a whole lot of, these are rich people, famous people fighting about nothing. Why should we spend our resources that are putting bad people behind bars, that are awarding people custody and time with their children, that are, penalizing people that should be penalized, and we're going to give court time and taxpayer time to these people? They got a life. Move on.
All right, time's up. Perfect. Our power panel. Thank you so much, Paulette Lofton, Josh Schiffer, and Randy Kessler. Coming up, close.